Okay, hello everyone. Today I want to talk about inventive step. Now, uh, ch- today I want to talk about inventive step. Okay, so this is a question, right? We ask, is it obvious? So the term obvious is a legal term. It has a legal definition. A lot of people when they see obvious, they think like that's being offensive, saying, "Oh, you invented something." Oh, well, that's just obvious. It sounds a bit like derogatory, right? Like a bit of a put down. Okay. But it's not. It's a legal definition, okay? So we need to start. Let's start by looking. So I'm going to do this from a British perspective, okay? Because this will help us. Because the British, so the EPL and the UK follow the same law, but we use slightly different definitions, right? So let's start with the Patents Act 1977, okay? So this is the best place to start, okay? Patents Act 1977. So let's take a look at this. So we don't need the guidance, we'll just look at the act directly, okay? So, so we go with section one. So section one tells us what is and isn't patentable, okay? And specifically, we need to look at this, okay? So a patent may be granted only for an invention in respect of which the following conditions are satisfied. That is to say, A, the invention is new. B, it involves an inventive step. Okay, so this is the part that we're interested in. Involves a step. Now, let's think about this for a second, okay? So we're gonna take a look. I'm gonna sort of show you a hypothetical, okay? So this is just an example, okay? So I know, right? So I've got here two controllers, okay? So this right now this is slightly um contrived because this was released at this is actually a later release, right? But we've got an Xbox Series X controller that you can use with your PC or your Xbox, right? Play video games, okay? So it's just a standard controller. Let's take a look at some of the features, okay? So it's got two joysticks, okay? Got an on and off switch here. It also allows you to open up an app on your PC. Got some buttons here that have various functions. It's got other buttons. It's got two shoulder buttons at the back here. Two trigger buttons, two shoulder buttons, right? Okay, so it's just a standard controller and it uses a battery and it specifically uses two AA batteries to work, okay? Right? This, right? Now, again, I know this is an earlier release, but this is just for an example, okay? So let's bear with me. So it's got basically all the same features, right? More or less as the other controller, right? But what we're going to look at the back here is this, okay? Got this. This allows you, these buttons allow you to change how deep press. So the bottom one, this barely moves. Middle moves a little bit more. Top, it goes down a lot. Okay. So let's pretend, right? We already invented this. Okay. So this just has standard shoulder buttons. They go down all the way. They depress. So they fully depress, right? What would be fully depressed on this one, right? Someone comes along and says, I've got this new controller, exactly the same as this one, but got these three toggles that allow you to adjust the depth of these trigger buttons. So this can be more sensitive, or less sensitive, more sensitive. Would that be an inventive step? Do you think that would be obvious? So how do we test for that? Okay. We sort of say, this is our starting point, right? We don't know about this other controller yet. We have to think about what's called the skilled person in the art, the skilled guy, right? So he doesn't know, he's got no knowledge of this. So that means viewed without hindsight. So he only knows about this one. He doesn't know about this. He doesn't know any of the features of this. He only knows this one, right? And we're asking, would it be obvious, right, to do that, right? Would that be an obvious addition to do that? Okay, so that's just a thing to think about, right? And I'll tell you my opinion on that later, right? So that's just an example to get you thinking about it, right? And you can think about it with lots of things, okay? Think about it with this, for example, right here, I've got my drinks cup, okay? And let's pretend again, right? Let's pretend, right? So this comes with a straw, okay? So I've been using it, so it's a little bit dirty, but that's okay because I've just been using it. But it comes with a straw, right? On the bottom of the straw is this deformable rubber. This deformable rubber attachment, right? And what's that good for? So when I put the straw in here, I close the lid. Then I can just close this like this, because the rubber pad deforms at the bottom of this. And then when I want a drink, I open it and the straw just pops out so I can just drink, right? So let's pretend, right, that we had a straw without the deformable rubber pad and someone came along with the deformable rubber pad that does that. Would that be obvious, right? So these are things to think about, okay? And then to give you one final example, okay? Um, let's pretend that I have come up with. So I've got. So this here is my Nintendo Switch Pro controller, okay? And I only have one of these, so I'll have to use a bit of imagination. So let's pretend, right, that we invented a new Switch, or Nintendo comes along with a new Switch Pro controller. So you can see very similar to the Xbox ones, right, in shape and design, right? But let's ignore that for now. Let's pretend that my new invention was simply changing the color scheme of this controller. Would that be obvious? Okay. So again, I'm not going to tell you the answers just yet. We're going to discuss it, and then I'm going to talk about inventive step a little bit more, and then we'll think about what are the answers. Okay. So those are two. So these are just a few examples, right? We think about. We look at inventions, and remember, we have to do this. This is called viewed without hindsight. Okay. So we're viewing this with no knowledge of what happened. Okay. So helpful with no knowledge of previous um with the previous inventions, right? So let's take a look at what inventive step actually means. So we're going to look at the manual of patent practice, right? Or MOP, as we call it back in the day, or I think they still call it that, MOP. Okay, the manual of patent practice. So this is what all patent examiners read and use to help them decide on issues like inventive step, okay? So let's take a look at section 3, which is inventive step. So this tells us about obviousness, okay? So we have a few court cases, okay? So this one comes from the Court of Appeal. So this is Windsurfing versus Tabor Marine, right? Which tells us how to do inventive steps. So we're going to look at the UK approach first. Then we're going to discuss the EPO approach, and then we'll discuss the US approach, which is completely different from both. So the UK approach and the EPO approach to deciding inventive step are a little bit different, but in theory, we should come up with the same answer because UK law is based on the European Patent Convention, which is what the EPO is, and the EPO grants patents that are valid in the UK in theory. So ideally, or in theory, we should arrive at roughly the same answers, which is why, and I prefer the UK approach because that's what I was trained on. But we are going to look at how the EPO does it, how the EPO decides this as well, and how the US decides this. But I think it's good to start with the UK approach because the UK approach I think is a little bit easier to follow, and it's a little bit more logical in its implementation, right? So there was a court case, 1985, Windsurfing versus Tabor Marine. And then it was a follow-up case, which was which is called Pozzoli. Okay, so what does it say? So what did they say in windsurfing? It said the question of whether the alleged invention was obvious has to be answered objectively by reference to whether at the material time, that is immediately prior to the priority date, the allegedly inventive step or concept would have been obvious to the skilled addressee. So this is the thing that we use a lot in patents called the skilled addressee, skilled person, or person skilled in the art, okay? So let's get back to our controller example. What does that mean exactly? It's person skilled in the art. So I've got this here controller, right? And I'm saying I want to ask if this controller with the adjustable trigger switch is obvious, right? So knowing only about this, right? So who is the skilled addressee? He's someone that's an expert in making game controllers, right? That's his skill and knowledge, and that's all his skill and knowledge base is, making game controllers, right? But and he knows everything about it. So we have to also establish, and we'll get to this in a minute, what would be common general knowledge, but it has to be at the time of the priority date. What was common general knowledge then? And specifically viewed without hindsight. So that means if I said, "Oh well, doing this would be obvious, right?" But that's only because I already know about this, then it's not obvious because that's using hindsight. Because everything in hindsight is obvious. But we have to start with this and then say, would it be obvious to go to that? Okay, without knowing about that, we don't know that as far as the skilled person is aware, that controller doesn't exist, right? He only knows about this controller. He knows about all the other controllers that were made prior to this. So SNES controller, NES controller, NES controllers, Mega Drive controllers, all game controllers that were made before this one. Those are all the controllers he knows about. He doesn't know about that controller because it hasn't been invented yet, as far as he's concerned. And then we want to ask, would it be obvious to add these adjustable switches on the back here? Okay. Now, so that's it, right? And then he says, what has to be determined is whether what is now claimed as inventive would have been obvious, not whether it would have appeared commercially worthwhile to exploit it. And again, and that's also an important distinction because it's not about, is it valuable, is it marketable, is it something that's going to be worth a lot of money. It's not about is it good, it's about is it obvious. So one thing one of my former bosses used to tell me is that something isn't obvious because no one in their right mind would do it that way. Okay? So in other words, what you're doing is just goes so against, like it actually makes it worse, not better, so therefore it's not obvious. Right? That's also one way to determine it, right? So we can go a bit further down. We don't need to necessarily worry about this yet. But we look at how do we identify obviousness? So the windsurfing approach was this. Step one, identify what is the claimed inventive concept. So we'll look at an example of this in a minute. And we'll actually look at the windsurfing case specifically, and also the Pozzoli case as well. Right. So identify claimed inventive concept. Assume the mantle of the normally skilled but unimaginative addressee in the art at the priority date and impute to them what was at that date common general knowledge of the art in question. So again, that's a very important distinction point he makes. Unimaginative, right? So that means that the skilled addressee, right? He knows all about these controllers, but he can't imagine that the Elite Series controller over there. He can't imagine he can't imagine any controllers that haven't been made yet. He only knows about this controller and all the other controllers that have previously been made, but he doesn't know about any of these other ones, right? So identify what, if any, differences exist between the matter cited as being known or used and the alleged invention, and then decide without any knowledge of the alleged invention whether these differences constitute steps which would have been obvious to the skilled person or whether they require any degree of invention. In other words, so if we look at the inventive concept, we look at the prior art, we look at the difference between the two, prior art here, inventive concept over here. So look at the difference and we say, what would the skilled person need to do to go from prior art to get to inventive concept? What would that involve? Right? And the thing is, that's different depending on what it is. For example, I had a boss that used to work in washers, right? For thingy, what do you call them? Nuts and bolts, like washers, right? or bricks, and they would say that basically these arts are so well studied and so old that if it's new, it's obvious. The bar for obviousness is very, very low because so many people have studied this that if anyone comes up with anything new, it's basically obvious by definition, just because of how much knowledge is out there, right? Effectively. So it's a very low bar for certain things. It's a much higher bar for others. For example, in computing. Um, in computing, we don't really, a lot of things are changing all the time. So coming up with something new may well be obvious because people are kind of looking at it. People are sort of constantly coming up with ideas, constantly thinking about things, and that, like, for example, I mean, it's just an example in computing. Let's say that I had a case from a private applicant who had some sort of networking system, and then instead of making it wired, he made it wireless. And I said, well, that's just obvious because from based on his own prior art, I mean, based on his own previous invention, I said it would be obvious because wireless is something that everybody's trying to do, so having things wired is going from wired to wireless is an obvious step, right? Um, so it's stuff something like that, right? So let's take a look at the windsurfing approach. This was the first test, then it was reformulated. So in 2007, Pozzoli versus BDMO. And this is also a Court of Appeal, so that's what that means. EWCA Civ 588. That's the code. It means England and Wales Court of Appeal, and the code for that case is 588. So Jacob Lord Justice, he reformulated the windsurfing approach, which happens from time to time. So step one is to identify notional persons skilled in the art and their relevant common general knowledge. So that's step one. Then identify the inventive concept. Step two. So again, you're looking at the claim. So this is claim one, by the way. So we're not worried about claim 10. We're worried about claim one because that is what we're granting, claim one. The dependent claims, all the other claims don't really matter for that. Well, they don't matter in the sense of if it's not in claim one, it doesn't really count. So there might be an inventive concept in there, but they'd have to amend it to put it into claim one. Okay. So identify the inventive concept of the claim in question, or if that cannot be readily done, construe it. So sometimes claims are not clear, so we have to sort of work out what the inventive concept is based on the description, based on the claims. What have they invented, right? Or what's the inventive concept? Then we identify, again, have identified the differences between the prior art that we cited, that we found, and the inventive concept. And then, again, this is it. This is the important thing. Without hindsight, so in other words, viewed without any knowledge of the alleged invention as claimed. So again, we know about the prior art. We don't know about the invention, right? Are those differences something that would be obvious to the skilled person? So like my example, going from wired network to wireless, that generally is something that would be an obvious thing because wireless is so ubiquitous now that changing something from being wired to wireless would not be classed as inventive, in my opinion, right? So let's take a look at an example of this, right? So we'll actually look at Pozzoli, okay? Because I think it's important to look at an actual case, and the easiest ones to look at are these cases, okay? Once we've done that, then we'll take a look at so once we've done that, then we will take a look at the European EPO approach, and then we'll have a quick look at how the Americans do it, because the Americans are slightly different, right? So let's take a look. So this is so the Pozzoli, so this is the High Court, which is the lower court. So Judge Lewison, who was the judge in that case, he said that this patent was invalid. So let's take a look at the Pozzoli. Let's take a look at the actual patent. Okay, why was it invalid? Okay. And it was invalid on the grounds of obviousness. So I want to take a look at the actual patent itself. So Here we go. Let's take a look at this because this is the right. So this is the actual patent, okay, that we're talking about. So inventor is Pozzoli, the Italian guy, and he's also the applicant, hence Pozzoli. All right. So let's take a look. What was this actually for, Pozzoli? Right. So we got container for plurality of disks, compact disks. Okay. So this is like a disk changer. So the present invention relates to a container for a plurality of disks, particularly compact disks, for which comprise a tray-like body having on its bottom a first flat surface and a second flat surface arranged side by side at different levels. The container comprises a first swing-out frame pivoted to the tray and accommodatable at the first flat surface, and a second swing-out frame pivoted to the tray and partially accommodatable on the second flat surface so that the remaining part overlaps and is spaced from the first flat accommodated on the first flat surface. Each frame supports two disks on opposite faces. And right. So, and there was some documents cited against that. So let's take a look. So these are so this is cited as an X and a Y. So in other words, what the examiner was or what the appeal examiner was saying in this case was that this is novelty or inventive. So this document is novelty and inventive step against claims 1 to 4. Y means that when it's combined with this document, that it would be obvious. Claims 5 to 8 would be obvious. Okay. Now, so now I want to take a look. So that's just okay. So I can't see the claims. That's okay. Right. So we're gonna take. So why was it rent? So it was obviously granted eventually. So let's see. So windsurfing. So the reason why, okay, so the reason why windsurfing was reformulated as Pozzoli is because it was a case under the 1949 Act, which was the previous act to the 1977 Act, and he's saying the European Patent Convention uses the word state of the art. So that means, so in this case, Pozzoli was what, 1994. So that means in 1994, what was the state of the art of these multi-layer compact disc trays, right? Okay. So let's see what else they say. So let's see. So let's see how he does it. Let's see how the judge does this. So the notional person is the skilled in the art as someone who might wish to package discs or make or design the packaging for discs such that a person might work for a media packaging company or might be a customer who wanted a particular kind of packaging. Although there had been a bit of a dispute about this below, the conclusion is not and could not be challenged on appeal. So this isn't even a disc changer. This is just a way of packaging discs, of packaging lots of compact discs in these layers, right? So let's see. Agreed that the notional addressee would know about common forms of packaging CDs. At the priority date, these included the jewel box. This was the standard container for one CD, where the CD was retained by central coupling known in the industry as a rosette. The digipack. This had a plastic tray with a central rosette attached to a folder of cardboard that formed a back cover, spine, and front cover. The digipack had finger or thumb recesses around the periphery of the disc to assist in the removal of the disc. The Brilliant Box, plastic sleeves, multi-disc digipacks. These are digipacks with a tray glued to both the front and back covers, which contain more than one disc. The multi-disc jewel box. This was a box with a central core element and front and back lids opening like a book. The 2-1 tray. This was a tray with recessing for accommodating two CDs side by side. Since a tray made to accommodate one CD is virtually square, a tray made to accommodate two has the dimensions and ratio 2 to 1. So I don't know if you know about CDs, if you remember all of this. CDs obviously quite a long time ago now, but I remember a lot of these myself. In addition, it was common for CDs to be packaged in cardboard sleeves. This form of packaging was used for CDs given away free with magazines and newspapers, and also for CD singles. A CD has a hole in the middle. The conventional method of retaining a CD within its packaging, apart from plastic or cardboard sleeves, was by means of a rosette fitted into the central hole. So that's what they called it. They used to break all the time. I remember those things used to break all the time, and it was really annoying. The rosette prevents the CD from moving laterally and also prevents it from moving vertically. Rosettes differed in the details of their design, but all operate in essentially the same way. One or two people have given some thought to other means of retention, e.g. by peripheral clamping or tabs, but these were not part of common general knowledge. One of the sources of common general knowledge would have been the trade publication 1-to-1. There was no relevant textbook. At the prior date, there existed three main types of discs: optical discs, such as CDs, magnetic discs, such as floppy disks, and mechanical discs, such as vinyl discs. Magnetic discs, such as floppy disks, typically had their own internal packaging, i.e., the outer rigid plastic casing. There are other discs, such as mini discs, and I remember those, which were magneto-optical discs. These discs had integral packaging. Hey, right, so let's see. So let's go over there. Oh, knowledge. So what's the inventive concept? Having identified the skill man is common general knowledge, then we need to work out what is the inventive concept. The present invention relates to a container for a plurality of disks, particularly compact disks. It is known the containers for a plurality of compact disks are generally constituted by a tray-like body that forms side-by-side recesses for seats for accommodating compact disks. This arrangement causes the dimension of the container to have a 2-to-1 ratio, so that said container assumes external dimensions in addition to being scarcely effective from aesthetic point of view, are often awkward since they do not allow to easily place the container in areas where it is to be held. We're overcoming this 2-to-1 container problem. So we're allowing it accommodate two or more disks, allows them to remove them individually and reduce the external dimensions, thus making it easier and simpler to position and head container in the areas where it's to be held. So it's basically for putting on a shelf. The patent then says that the objects can be achieved by a container in accordance with Claim 1. Lewis and J conveniently set this out broken into elements. So we got all these different elements. Container for a plurality of disks, comprising a tray-like body, defining seats for accommodating at least two disks. Said tray-like body, including a first region. Right, so we got all these different features. So let's take a look at what was the prior art. So differences. Difference is essentially the idea of overlapping yet spaced apart rather than side by side, the 2-to-1, or concentric, the brilliant box. So like this. So it's like this instead of like this, or concentric, I guess, would be like this. So the reason that this has gone to the Court of Appeal is they're trying to say that the judge in the High Court made an error in law. In other words, that he misapplied the windsurfing approach, which is why this has come to the Court of Appeal. So this is something people don't often realize in law. If you want to appeal the judgment, so the High Court said that the patent's invalid on the grounds of obviousness. If you want to appeal that, you have to demonstrate that the judge made an error in law. You can't appeal just because you don't like the result. So if you don't like the decision, you can't appeal simply because you don't like the decision. You have to show that the judge actually made a mistake in law. So Mr. Meller, who I'm assuming is the representative for Pozzoli, is saying that the differences, this bit, step 4, would the difference be obvious that the judge had made an error when he was applying that? So he said, so this is what he said, why he thinks the judge made an error. He said, the patent teaches for the first time the idea of overlapping CDs without any form of protection between them. The judge wrongly rejected the case that the skilled man would be prejudiced against overlapping by a fear that the CDs would be at risk from damage to their playing surfaces upon removal or replacement, particularly the lower one. So he's saying that you might scratch the disc when you take it out. The evidence, so that's one thing that the invention does that the prior art doesn't, is that it allows you to take a disc out without scratching it, basically. Um, the evidence which the judge accepted as establishing obviousness was tainted by hindsight. So again, remember I said can't use hindsight. In particular, it is only if you have the idea of reducing the height of a 2-to-1 that occurs to you that this can be done by overlapping and separating the discs. The judge wrongly identified the inventive concept of Claim 1 as finding a way of reducing the height of the 2-to-1 container without exposing the disc to serious risk of damage. Uh, so the judges said, this is true, but he's rejecting that argument. Takes Mr. Mellor nowhere. If it were so, then this would be the case. This would be a case of anticipation, not obviousness. In all cases where there is no anticipation, a similar point can be made. Point two fails for the reason I've identified at 34 to 37. So although it is true that no one had proposed overlapping CDs with no form of intermediate protection, that was not because of the alleged prejudice. There was simply no demand for such a product. Um, so um, in other words, what he's saying is that so he says patent teaches. So why is he saying he rejected point one? He says he rejected point one. So he said if it were not so. So in other words, if it were not so that that this wasn't the first time the idea of overlapping CDs without of teaching for the first time the idea of overlapping. Oh, sorry. Then yeah. So this would be, in other words, if this wasn't true, then the patent would it would lack novelty. It wouldn't be inventive. We would be talking about novelty, not inventive step. Sorry, yeah, that's what he means. So in other words, um, so in other words, what you can say is that if something just because what he's saying is just because something's new doesn't mean it's not obvious. Is what that means. So anticipation means it's new. It's not new. Something else has already shows that feature. So what did he say in 34 to 37? He said that he submitted that the 2-to-1. Hang on, let me just see. 2-to-1 CD cases. I'm just kind of trying to remember what these look like. Ah, here we go. Yeah. So I don't know if you remember these, but I remember these things. Yeah. This is what he's talking about, the 2-to-1 CD cases. I don't know if you remember these, but I remember Um, these things. So they're trying to say that these things, you're overcoming these things with this kind of multi-layered sort of stacking thing. Um, so, um, and also that you're having to put them together like that because then it's the top end, which you don't need to worry about scratching, that are coming together, not the opposite, not the underside, which has the information that you don't want to scratch. Okay, so that's just to remind myself what they were talking about with these 2-to-1 stuff. They said it was an inconvenient shape, and the judge could not reasonably conclude that people did not want a better shape, such as is achieved by overlapping. So one must infer that what had prevented them doing this was a prejudice. But I do not think this works. First, there was clearly evidence on which the judge could make his finding. I have just quoted. Second, Mr. Miller's submission presupposes that the 2-to-1 was all that was available for multiple disc boxes, but it was not. The folding out brilliant box was very well known and used. So let me just take a look at this. So CD case folding out brilliant box. I'm trying to remember what this was. Take a look. Okay, so this was okay. So I do also remember these things as well. Yeah, these were the trifold ones. Okay, I remember these as well. Okay. Um, And it was the same nearly square shape as a single CD container, but thicker. You do not even have to be a person skilled in the art to know about them. They are everyday objects. So what had to be shown and was not was that there was want for an intermediate height of container, a want unsatisfied by reason of a prejudice. The judge expressly held that this was not the case of a long felt want. This conclusion is hardly surprising given that the first physical embodiment of the Pozzoli patent, which was placed in the market, failed to achieve commercial success. Of course, this is post-priority date information, but tells us that at the priority date, the skilled man did not have any want in mind, for there was none. That is not to say that people did not appreciate the 2-to-1 was not an inconvenient shape. They did. However, these drawbacks were ones that Mr. Plum himself was aware of in 1994. He also considered that these problems were generally known at the time. So in other words, the issue that Pozzoli is trying to overcome is one that was known about. It's just that people didn't think that his solution was a good one. So that's why they didn't do it, in other words. Point three, the evidence, the hindsight. So this is saying that the judge used hindsight. There was evidence that people appreciated that 2-to-1 was an inconvenient shape, but not that they wanted something taller than a brilliant box, but shorter than a 2-to-1. It is self-evident that if you did, overlapping would be essential, but no one wanted to do that. Having the idea of reducing the height was not in any way a technical advance, just another way of packing two CDs. So they're basically saying that because there was no need or want for this, that basically that it had been considered and no one wanted it, what they're saying. So point four about the inventive concept is true, but I do not think that matters and was not, as I read it, the key to the judge's reasoning. The key question is whether it was inventive to overlap, space apart, and provide ready removability. The judge specifically considered that and thought not. He said, in my judgment, the evidence inexorably leads to the conclusion that if you wanted to reduce the height of a 2-to-1 container, it was obvious to overlap the discs and separate them physically. Working out how to do it would have also been obvious. Um, so in other words, it's saying that if you want that by design, the problem that you've got, which is that the 2-to-1, as they call it, is too tall, and you want to make it shorter, that this was the natural way to do it. So therefore, that makes it obvious. There was ample material to support that. Mr. Mello submitted that it was on the wrong basis. The false basis being if you wanted to reduce height. Only if you have that idea, does the rest follow? The trouble with that attack is the judge's finding that it was known that the 2-to-1 was too high. It's hardly inventive to consider reducing the height in those circumstances. Once you consider that, you must overlap and the rest follows. So in other words, what they're saying is you want to make it the 2-to-1 shorter, then this is like the only way that you would do it. Therefore, it would be obvious to the skilled man. It doesn't require inventiveness. So so they're saying that basically the patent is invalid. So they must so it looks like basically what happened was that someone Pozzoli tried to sue someone for infringement. And the typical response to an infringement lawsuit is to say that your patent is invalid. So that's what happened, and that's what happened to Pozzoli. So this is something as well. This is another good point that you need to be careful of. If you try to litigate a right, you run the risk of losing your right. So Pozzoli had a valid patent, and he tried to litigate it, and then he ended up losing it, which is so this is also something to be aware of. So the three Lord Justices, we got Lords Justice. So in the Court of Appeal, there's typically three justices. On the House of Lords or Supreme Court, you usually get five, and they all agreed with each other. So so it was an infringement case, but this is the important bit. even if the patent had been valid, I would not have held it infringed. The alleged infringement does not have one region higher than the other than another. So there was a lawsuit. So Pozzoli obviously took someone to court for infringement, and his patent, not only was his patent found to be invalid, it was also held not to be infringement. So he lost on two fronts. So that's obviousness from a UK perspective. I think we'll leave it there because I think for the next video I want to do obviousness from the EPO's perspective. And bear in mind that the EPO law is going to be similar to UK law. Well, the EPO law is based, sorry, excuse me, UK law is based on the European Companion Convention, which governs the EPO, but they use a different test. And in theory, they should arrive at the same answers, right? So it's just their case law sort of deviated slightly. But I thought this was kind of an interesting sort of insight into how we assess obviousness. And this case in particular is a good one to look at because we're talking about what was the state of the art in 1994, because they're doing this in 2007, so 13 years later. And you need to ask, but you need to go back to when you can't go from 2007 because there may have been progress in CD cases in the intervening years, in those 13 years between. You need to go all the way back to 1994 and say what was known in 1994, not what's known now, because that's not really relevant. So hopefully that helps with a little bit of insight into Inventive Step and how we assess Inventive Step. So I will talk to you guys later, and hopefully, and we'll do another video on this later. So until then, take care and bye bye.